Leader.
Mr. Speaker, I beg to move that the proceedings on the business set down on the order paper for today be exempted at this day's sitting from the provisions of Standing Order Number 2.
The question is the motion moved by the Leader. As many as are of the opinion say aye.
Aye.
To the contrary say no. I think the ayes have it. The ayes have it. Mr. Zhulkarnain, Abdul, Rahim.
Mr. Speaker, sir, I declare my interest as a practicing lawyer. In 2018, I submitted written and oral representations to the Select Committee on Deliberate Online Falsehoods. I raised the need for us to be mindful of the power of lobbyists with political or commercial objectives who may fund the spread of falsehoods online and cause divisions in our society. I expressed that social media and online news websites should be transparent on its funding and/or political affiliations. I was concerned about sinister campaigners meant to spread disinformation, evoke emotions, provoke reactions to advance a certain agenda. Intrinsic in what I said was how easy it was for any foreign principal to interfere in our social compact and political institutions if there are no checks on transparency or accountability. This bill seeks to address that. There has been many discussions on this bill outside these chambers. However, I think as Singaporeans, all of us can agree on the following two fundamental principles. First, that Singaporean politics must be determined and decided by Singaporeans alone. Second, Singaporeans all want open and transparent discourse in politics, one that is accountable to Singaporeans and not motivated or interfered in a covert or deceptive manner. In this speech, I will focus on foreign interference by electronic communications activity. My speech will be in three parts. First, my thoughts on the threshold proof required to best protect our national interest. Second, my clarifications in relation to the mechanism to safeguard our collective interest. Third, the importance of maintaining trust and defending the institutions of our country, which I will deliver in Malay. The foreign interference threat that Singapore faces can take various forms and employ different tactics. These tactics evolve over time and are difficult to track. In New Zealand, the Ministry of Justice, in a statement on mitigating foreign interference, stated that, quote, due to its covert nature, direct evidence of foreign interference on our democratic system and its impacts can be difficult to obtain and often emerges post facto, unquote. The situation in Singapore is no different. By the very nature of foreign interference, direct evidence of the same is very difficult to find, much less to prove. Oftentimes, if we wait for such direct evidence, it will be too late. Against this backdrop, I'm concerned about the amendments proposed by Member James Lim, as I fear that in actual reality and practice, these amendments may potentially blunt the protection under the Act and weaken the steps that our civil servants can take to protect Singapore and Singaporeans from covert foreign interference. There are two main categories of amendments which I'm concerned with. First, the amendments relating to the mental state of mind of the perpetrators in clauses 17, 18, 20, 40, and 75 of the bill. Second, the proposal to introduce a new threshold of proof in clause 21. On the proposal to amend the mental state of mind in the offences to require actual knowledge, it will be difficult to prove that a person actually knows that his action is prejudicial to Singapore's national interest. It will be too easy for perpetrators to just disclaim knowledge that something is, for example, prejudicial to the security of Singapore. This may have the unintended effect of weakening the protection of our national interests under the bill. Such knowledge or belief must be pegged, I think, to an objective standard of likelihood, which any reasonable person ought to have in the circumstances, which is what the current wording in the bill suggests. Specifically, on the proposal to remove Clause 17.2 subsection A and Clause 18.2 subsection A, this effectively means that a perpetrator must have in mind a particular foreign country or principle during the activity. However, in reality, foreign state or principles are likely to disavow any links to HICs. I think it matters less who that foreign principle is, so long as we know that the perpetrator is acting on behalf of a foreign principle. The fact that one is a puppet on a string is enough without needing to know or prove who the puppet master is. In relation to the powers of the minister to issue anticipatory directions, I can understand that given the urgency and covert nature of foreign interference, the authorities may require action to be taken on the basis of reasonable suspicion, which is a standard well established in law. This means that the reviewing tribunal or the courts can be guided by past case law and decisions to assess if indeed the minister has fulfilled the legal threshold to issue such anticipatory directions. On the contrary, there is no established standard for an evidence or actionable intelligence test in the common law or Commonwealth jurisdiction. Ultimately, I think the member and all of us here want the same thing, which is greater certainty and clarity before the issuance of such directions. In practice, the test on reasonable suspicion is objectively met if there is a reasonable suspicion or belief and that it is in the public interest to do so. This is based on Court of Appeal cases that have construed the meaning of reasonable suspicion test. This is not Hollywood. This is based on case law, with a judiciary that carries out its duty with no fear or favor. I now move on to my second part on the clarifications to further safeguard our national interests and Singaporeans. I have 5 clarifications in this regard. First, in relation to Clause 17 and 18 of the bill, is it a requirement for the perpetrator or accused to actually know that the proxy was indeed acting on behalf of a foreign principal? What if he or she does not even know that the proxy was acting for a foreign principal? Alternatively, he or she may not know that the proxy was acting on behalf of an undisclosed principal. What would the approach be then? I ask these questions because it should not be made easy for perpetrators to disclaim actual knowledge in situations where they could or they ought to have made reasonable inquiries with the proxy regarding the principal. This is not an ordinary crime or offense we are talking about here. The stakes are too high, given the harm and prejudice that can be caused to our country. Second, with regard to Clause 16 on determining the purpose of an activity or conduct having regard to the intention or belief of the persons involved. What is the threshold of determining such intention or belief? Does such belief need to be objectively ascertained or on a reasonable basis? Also, what is the approach, assuming there is more than one or competing beliefs or intentions? Third, on what is to be determined as covert or clandestine, may I ask the Minister, what about the communications over WhatsApp or other end-to-end encrypted messaging platforms or communications through VPNs? These are widely available and platforms commonly used. Do we consider the varying degrees of concealment? On the flip side, if there was no attempt at all to hide the prejudicial interference, then I think the perpetrators should still not be allowed to get away with it. Fourth, on the reviewing tribunal and judicial proceedings, Clause 112 makes every offence in Part 3 arrestable and non-bailable, and the rest of the offences arrestable. In this regard, what are the measures that will be in the subsidiary legislation or otherwise to ensure that the reviewing tribunal proceedings can be concluded expeditiously? Also, given that such proceedings will touch on matters on national security or an interest, what are the safeguards in place to ensure the confidentiality and the secrecy of the information or any evidence produced in those proceedings, whether under the OSA or other applicable legislation? Fifth, I feel that it would be useful for the public to know on a periodical basis the types of threat and attempts of foreign interference made. I can understand that full disclosure would be extremely sensitive to the mission success of any intelligence operations. However, perhaps MHA can consider from time to time giving a report on the FICA offences or directions without the need to go into the specific details on naming the individuals or foreign principals involved. This way, Singaporeans and the public can appreciate the good work done behind the scenes by the men and women of our public service to protect our national interests and at the same time maintain and increase public confidence in the public service and government. Mr. Speaker, sir, for the final part of my speech in Malay, please. Setiap negara melakukan aktiviti untuk mempengaruhi, membentuk persepsi dan membuat keputusan di negara lain. Ini lumrah diplomasi antarabangsa. Namun, kegiatan ini menjadi tahap campur tangan apabila ia sengaja dilakukan secara tidak bertanggungjawab untuk merosakkan kedaulatan negara lain. Dalam kajian oleh Institut Penyelidikan Strategik di College Tentera Perancis atau IRSEM yang baru diterbitkan minggu lalu, Singapura didapati amat terdedah kepada aktiviti campur tangan pihak asing. Pertama, tahap literasi digital di negara kita yang tinggi bermaksud kempen campur tangan di talian amat mudah untuk dilaksanakan. Kedua, oleh kerana masyarakat majmuk kita, pihak-pihak yang tidak berniat baik boleh cuba untuk memecah belahkan kita. Oleh itu, adalah wajar bagi kita sebagai satu negara untuk memperkukuhkan lagi perpaduan antara kita dan kepercayaan bersama pemerintah dengan menyemak rangka undang-undang demi membenteras anasir-anasir yang cuba memecah belahkan kita. Akta ini bertujuan untuk mencapai matlamat ini. Dalam ucapan bahasa Inggeris saya telah mengungkap kembali pengalaman saya sebagai pemimpin masyarakat dan peguam semasa saya memberi keterangan di jawatan kuasa terpilih mengenai kepalsuan dalam talian pada tahun 2018. Saya telah meluahkan keprihatinan saya bagaimana media sosial dan laman web berita dalam talian harus telus dalam sumber pembiayaan atau kaitan politik mereka. Tersirat dalam keterangan saya adalah kebimbangan saya betapa mudahnya sebarang pihak asing boleh mencampur tangan dalam politik negara kita dan mengganggu kestabilan institusi sosial dan politik kita. Malah ramai lagi pemerhati dan individu-individu yang telah memberi keprihatinan yang sama dalam jawatan kuasa terpilih tersebut yang telah disenaraikan oleh menteri tadi. Dalam peranan saya sebagai naib pengerusi jawatan kuasa Parlimen Pemerintah bagi hal ehwal dalam negeri dan undang-undang, saya juga telah terlibat dalam pelbagai perbincangan dan konsultasi tentang isu campur tangan pihak asing yang dibayangkan dalam akta ini. Oleh itu, perbincangan tentang ancaman campur tangan pihak asing yang terselindung ini telah pun berlaku lebih daripada 3 tahun yang lalu dan bukannya baru-baru sahaja ini seperti mana yang disifatkan oleh Yang Berhormat Ketua Pembangkang Encik Pritam Singh. Malah Encik Singh juga adalah ahli panel dalam jawatan kuasa terpilih di 2018 dan beliau hadir semasa keterangan saya pada tanggal 27 Mac 2018. Tuan Speaker, akta ini membolehkan pihak kementerian untuk mengambil langkah-langkah strategik terhadap dalang atau orang tengah yang merupakan musuh dalam selimut di negara kita. Aktiviti atau perancangan mereka sukar dikesan dan kadangkala kita harus melakukan tindakan dengan segera sebelum nasi menjadi bubur. Ini bukan sesuatu yang baru. Sebagai seorang peguam dalam kes-kes antarabangsa di mahkamah dan timbang tara, kerap kali saya terpaksa mengambil perintah segera untuk memelihara bukti atau aset yang tertentu buat sementara waktu sebelum kes itu dihadapi ke mahkamah untuk perbicaraan. Bagi akta ini, untuk mengimbangi hak seseorang individu dengan kepentingan awam dan negara kita, akta ini memberi ruang dan peluang bagi yang tertuduh untuk membuat rayuan dan memberi bukti kepada tribunal yang menyemak perintah MHA atau Reviewing Tribunal. Saya fikir proses yang disarankan dalam akta ini munasabah. Ini memandangkan keadaan mendesak untuk mencegah aktiviti campur tangan oleh pihak asing dan akibat buruk pada negara dan warga kita jika aktiviti campur tangan tersebut berjaya dilaksanakan. Dengan cara ini, tiada gunting dalam lipatan yang dapat memecah belahkan masyarakat majmuk kita. Pihak kementerian juga harus memenuhi syarat-syarat yang ditetapkan sebelum boleh mengeluarkan perintah melalui akta ini. Ini berdasarkan takrif yang telah dilandaskan dilandaskan kes-kes undang-undang sebelum ini. Malah, pihak mahkamah tetap ada kuasa untuk membuat semakan kehakiman atau judicial review dalam kes-kes tertentu mengikut bidang kuasa mahkamah yang wujud. Singapura juga mempunyai reputasi dan kepercayaan yang tinggi terhadap pihak polis dan pemerintah, sistem perundangan yang mantap dan badan kehakiman yang bebas. Jikalau benar seseorang individu itu tidak terlibat, amatlah mudah bagi dia untuk menyangkal tuduhan tersebut dengan bukti yang kukuh. Tetapi dalam pengalaman saya, bagi kes-kes jenayah serius, terutamanya terhadap negara dan seluruh masyarakat kita, pihak penyelidik dan kementerian tidak akan sewenang-wenangnya menuduh seseorang itu tanpa sebab munasabah atau bukti. Takkan pokok bergoyang jika tiada angin meniupnya. Kita sudah berdekad lama merdeka, namun perang penjajahan minda masyarakat kita terus wujud. Ayuh kita bersatu dan memperkukuhkan kepercayaan antara kita dan dalam institusi negara kita. Mr. Speaker, sir, in conclusion, the law and our public officers operate in the light to protect us, while sinister, clandestine actors operate in the shadows against our collective interests and our country. Hence, we should even the odds in this fight. Let us put our trust in the men and women of our public service and grant them the tools that they need to uphold their sworn duty to protect our lives and our Singaporean way of living. Notwithstanding the clarifications, I stand in support of this bill.